Good afternoon, everybody. Today is the first in my series for family law. And today I'm going to be discussing custody, parenting time, and child support. The general overview and how it works in the state of Michigan, things that affect your custody and things that don't. Things that have more weight than others and things that may not weigh as much as you may think. Now, custody, child support, parenting time is a very broad area. There are lots of things that have to be considered. There are lots of things that the courts look into, and there are lots of things that are weighed when it comes to initial custody and changing custody and parenting time. Now, there are two ways when it comes, well, actually there's more than two, when it comes down to establishing custody. Now, you have one situation where the parents are married. They both are deemed to have equal rights and say to their children at that time during the life of the marriage. And then there's a divorce. Once there's a divorce, unless the parents can agree to some type of situation, then it will be for the court or friend of the court to assist the parents in coming to an agreement. Now, when I say friend of the court, what I mean is they are going to look at all of the factors to help determine who the child should remain with. Who was the primary caregiver? What is the age of the child? They will even look at whether or not the child is breastfeeding. Whether or not the mother is breastfeeding and the child is nursing and how long that goes. First and foremost, however, will be what the parents decide. No matter what the court says, if the parents decide on a certain arrangement for their children, that would be the arrangement that would be taken into consideration and placed on the record. Now, that is if you have a custody situation where the parents agree. When they don't agree, you have friend of the court, you have referees, judges, and something called a FAME report, particularly in Wayne County, that can assist in making determinations of custody parenting time. Now, those will be handled in depth in another video, but this is more so for the general overview. Now, the other way that when it comes to a determination of custody and parenting time, when the parents are not married, is if one parent doesn't live in the household or moves out, and then that parent that has the child goes and files for child support. Or if that parent is on any type of state aid, then the state will file for child support and establish custody. For the purposes of state aid, when they file the complaint on the parent's behalf, what they will do is always request sole physical custody because the state is providing care for this child in the parent's custody. Once that occurs, the parent has the right, the other parent, whether it's the dad or the mom, has the right to go into court and object. They can request a new hearing. They can file motions of their own to contradict. But when there's a state aid situation, the state will always seek sole physical custody for that parent that is receiving the aid. Now, say that the parent isn't on any type of state aid, and the mom and dad were not married. In that situation, whatever parent has physical custody of the child, can still file a motion establishing custody, child support, and parenting time. Now, the reason that some parents will do that, and every situation is different. The reason some parents will do that is because when they establish that, when they file that matter, when they file the complaint, they want some type of fixed parenting time so that the other parent just can't come and take the child at any given moment. They want some type of set child support. Even if they're not receiving it technically from that parent at the time, that is what they're looking for, and that's why they're trying to establish the custody and parenting time. And they file that complaint. Now, if the other parent doesn't show up, then it's a default. And then the parent that filed that initial complaint will get what they request. They can put in their own figures for child support. They can put in their own request for parenting time, whether or not they want sole or joint legal and physical custody. And whatever they request, if the other parent doesn't object or deny, then that's what they're going to get. Now, the most common, I would say, of all is, well, let me rephrase that. What I see a lot of in some of the dads that I represent is that the state has filed for child support. Not mom, but the state did. Because either mom didn't have insurance and used Medicaid for her prenatal and delivery, or mom needed food stamps for a moment, or even dad, because there are definitely more occurrences and situations where dads are being left as the primary caregiver for children. So when that happens, and dad or mom is filed by the state will file, and then because there's no response from the other side, there's an automatic default. Overcoming that automatic default is one of the biggest problems that I see for, generally speaking, dads, because a lot of the times it's been set in place for an extended period of time before they've responded, before they go back to court or anything like that. And now they're stuck with this parenting time schedule or this custody schedule and these overnights that they have a burden to change. They have a burden to overcome in order to change. And the burden is not an easy burden, and there are several things that have to be looked at before the burden can be changed. Now, one of the biggest things that I find that most parents, even when they already have ongoing custody matters, even if they've already gone through a divorce, even if they have already filed for custody and trying to change things, is understanding the best interest of the child factors. The best interest of the child factors are approximately 13 factors that the court will look at to decide who should have custody. They will weigh each side, mom and dad. They will weigh the morality of each parent as is presented. They will weigh the income, the capacity of the parent to provide love. If there's any religious aspect that needs to be taken into consideration, they will weigh, depending upon the child's age, they will weigh the child's preference. They will look at domestic violence. They will look at the interactions between the parties. They will look at the education of the child, what school, the district, how far away are they moving, if they had to move them. There are quite a few factors that have to be looked at by the court, and they're not optional. Statute requires that the court, whether it's the referee or the judge over your case, to specifically indicate the fact, have an evidentiary hearing, or place the evidence on the record as to why they are changing custody or parenting time under the factors. Now, parenting time and custody, some people look at them as the same thing, and they're not. They are two different concepts. Custody, essentially, is who has physical possession of the child, who will maintain physical possession. And a lot of times that also includes the custodial environment. So if you have a child that has lived with mom for 3 years, dad maybe lived in the household for 2, moved out for 1. Mom has maintained physical possession. I hate to put it that way, but that's just what it is. Physical possession of the child for that full year. The court is going to look at mom as having the established custodial environment. Now, if dad wants to come back and say, I want joint, I want to be the established custodial environment, or if they come back and say, I'm the better parent, I deserve sole physical custody. Well, now they're stuck with a burden to overcome for that, for changing the custodial environment. Now they have a high burden to show that these factors are all in their favor, even though mom has taken care of the child for a year, has had the child in her possession for a year, the child has remained at this address with mom for a year, and dad only exercised parenting time maybe every other weekend. Now dad's going to have a much higher burden to change that parenting time. And the to change that custodial environment, because the custodial environment is what helps establish the school district for the child. It helps establish a lot of times the medical care for the child. If the parties live further apart, there are a lot of things that are affected by who has the custodial environment. Now, there are also situations where some parents share the custodial environment. Now, that type of situation occurs when the parents live close together. They live within the same school district. They have an agreement that they are going to share custody between the other parent, 50-50. That is when you can have a joint custodial environment, when you have parents that work together. It is rare that for a judge to just order it, especially if the parents do not get along, especially if they don't live close, especially if they are in different school districts. It is not generally going to happen. Now, parenting time outside of custody means that the time that you're allowed to spend with the child. So, say dad has sole physical custody in this example. If dad has sole physical custody, that means he has the established custodial environment, and he is the one with the primary physical possession of the child. Mom having parenting time means that she gets to spend time with the child on certain days at certain times. Now, sometimes you'll see orders that just say reasonable parenting time. But that leaves open the door for a lot of problems when you don't have specified hours and specified days. When you don't have specified holidays, specified traveling time, things of those nature. The reason you have problems when you have reasonable parenting time is because what one person thinks is reasonable and what another person thinks is reasonable can be two separate things. It does not mean the same thing. One person may believe reasonable parenting time is 50-50, regardless as to what custody says, 50-50. On the other hand, someone else may believe that reasonable parenting time is whenever the parent wants to come. Now, the problem with the reasonable parenting time, and I've seen that some clients having a big issue with this, is that there's no true agreement to enforce. So say you have a verbal agreement with dad or mom that you're supposed to pick the baby up from 3 to 6 on Wednesdays, and Friday after school to Monday morning you're supposed to drop off, and dad isn't doing it. Well, a normal remedy would be to file a motion for show cause. But when you have reasonable parenting time, there's really nothing that the court can enforce in regards to a definite schedule that you want, because there wasn't one presented. So in situations like that, you cannot even enforce or request the parental rights that you may have verbally agreed to when your court order says reasonable or reasonable and liberal. Reasonable and liberal for one is every day. I want to see my child every day. For the other, it may be, well, I think you're okay this week, I will drop the child off. And that doesn't work for the child, because consistency is one of the things that the court is also going to look for. Stability of the home, stability of the home life, and stability of the parents. Now, so that differentiates custody, which is, again, physical custody is like the physical possession of the child. Parenting time, which is the time that you spend with the child. And then there's legal custody. Now, most parents share legal custody. Most have joint legal custody. Legal custody is the right to make those big decisions for your children. Whether or not they should have a surgery, whether or not what type of medical care they should get, what school they should go to, whether or not they should be removed from a school, whether or not a child needs psychiatric care, whether or not a child should be able to join a particular religion or be part of a particular religion. All of those things go into legal custody. Most courts generally give joint legal custody out the gate. Now, when you have parents that are just highly contentious and highly litigious, one feels that they are the best at deciding what should happen or what they believe is going to happen, and they butt heads constantly with the other parent. That is when you can have a denial of legal custody, and the court will have to decide who will make those large decisions for the child. When the parents can't agree, when the parents cannot come to some type of meeting of the minds and what's in the best interest of the child, the court will decide. And I'll tell you right now, you never want the court just deciding what is going to happen with your child, the care for your child, and medical care for your child. The court gives people their rights to decide what's in the best interest of the child if they can. And they don't want it coming down to the judge either. Most judges will tell you that they don't want to make a decision as to who should spend time with the child, or who is going to have specific hours, or who's going to have joint legal, or what school the child is going to. Courts generally don't want to decide that. They do want the parents to do that, which is why they do provide lots of options to do so. Every county has their own options, but they do try to assist the best that they can in allowing parents to make those decisions themselves. Now, that covers parenting time, physical custody, legal custody. Now, you heard me mention something about these factors of the child, the best interest factors of the child. How is this being used to help you? How is this being used against you? Well, the biggest thing about it is when you file a motion, or you have an attorney file a motion to change the physical placement or the legal status, custody, parenting time of your child, there are certain things that have to be proved to make those changes. You or your attorney will have to show the court that these factors are overwhelming in your favor as to why this change should be made. You will have to show the court that you are morally fit, and more so than the other parent. That you have the capacity to love and share love and give to your child, more so than the other parent. That you have the best, sometimes siblings are taken into consideration. If there's an established sibling relationship in the household with children that you may have from a previous relationship, all of that takes into consideration the best interest of the child. So when you're thinking about changing or moving where your child should be and filing a motion to do so, you must know all of these things or provide all of this information to your attorney so that they can assess the likelihood of change and overcoming that burden. Now, just because you may think that, all right, I think we're pretty equal on most of these, okay, I think that, I just should have care. I'm mom. This is a daughter. I'm entitled. That isn't the best argument to present to the court. The courts are changing in terms of just feeling that moms should always have custody. Courts are looking at parents equally now, more so than ever. They are not just looking at the gender factors of children, whether or not it takes a man to raise a man, or whether or not it takes a woman to raise a daughter. They aren't looking at those typical gender roles anymore. They are literally trying to, for lack of better words, trying to calculate down what they feel under certain factors is best for a child. They're trying to piece together your life the environment that you provide, the environment that the other side provides, and determine where your child should be and who should be the primary caregiver, or if there should be a primary caregiver. The overwhelming theme in the law is that what's in the best interest of the child is joint physical, joint legal. The court does not look at it as the parent has the right to have their child all the time. They look at it like the child has the right to have access, equal access to both parents. That is the bigger thing. What are the child's rights, not just the parents? A lot of times as parents, we feel entitled to our children. And I'm not saying anything is wrong with that. But you have to show more than entitlement by birth or conception to the court in order to make the changes that you want. Now, when you're thinking about making those changes, and say you've made the decision yourself or you've gone to sit down with an attorney to help make those decisions, you should go through everything thoroughly with your attorney. It is imperative that your attorney knows everything, pros and cons, that are going to affect your case. Because that candor with your attorney will allow your attorney to craft the argument for you, to craft the best outcome for you, to craft the best motion for you. And we can't do that if we don't start with honesty. Now, these factors, and I'm going to stay on these factors for a little bit because, like I said, most walking in to try to change any type of custody or parenting time don't understand these factors. When you walk in to a judge or a referee to make these changes, you must be able to say, one, to the court, that you provide a stable life. Your child has lived in a stable environment with you for a duration of time, and that environment should not be changed. 2, you want to be able to show the judge or the referee that not only has your child stayed in this stable environment, but you have been able to provide for this child in a stable environment. Now, that doesn't mean that there's a problem with getting state aid whatsoever. That doesn't mean that you have to work 2 full-time jobs or anything like that. But that just means that you are providing for the child and the child's basic needs are being met. Food, shelter, clothing, education, safety. Those things are what the court is looking at. 3, you have to show that not only are you providing this stable environment, and not only are you able to provide the care for this, the care needed for your child, but you also need to be able to show the court that your child is attached to you, that there is a bond, that there is a relationship. Now, I know some people would look at that and say, well, that just kind of seems obvious. My child lives with me, I take care of them. It's clear that there's a bond. That's not necessarily the case, particularly when it comes to older children, or if you haven't had the child in your care for an extended period of time. So say, for instance, mom and dad get a divorce. Mom has maintained the children in her care for 3 months after this divorce, but for whatever reason in that 3 months, they haven't been really with mom. Say they've been at grandma's house. Say they've been cousin's house. Say they've still been spending more time with dad after the divorce. But not just that. Look back to prior to the divorce. What if dad was the primary caregiver during the life of the marriage and prior to the divorce? If he was the primary caregiver, then that is going to build weight in regards to the relationship that dad has with the children. If dad was the one who went to the PTO meetings, who went to, who volunteered for field trips, who chaperoned, who did activities, who did play dates. And this is a more increasing role. Please do not undercut this. This is a more increasing role. If all of these things are occurring from dad during the life of the marriage, a judge could easily find that dad had a stronger bond with the children, and that factor will weigh in their favor. So that's another thing to look at in being honest with your attorney or yourself or just the judge when it comes down to who is taking care of the children and who has provided this environment and who has a bond. Another thing you really want to think about when you're filing a motion or be prepared to argue to change custody or parenting time is your work schedule. Please know that it is hard to change overnights for custody if you work overnight. It is not that easy. Now, it's easier to get that established while you're in the midst of a divorce. That's been the parent's working schedule. There's another person in a home that has always helped take care of the children, something like that. But if you work overnight, if you work those twilight hours, then it's kind of hard to argue for more overnights. On top of that, please do not attempt to argue that, well, the child will be with grandma overnight, because then what you're saying is you're not even using your parenting time. You're not using the overnights you're arguing for. Someone else is getting the benefit of that parenting time. Someone else is caring for the children overnight. That is not a strong argument to go in and make in attempting to change custody or establish custody after you have this set parenting time schedule. Another thing when you're going in to attempt to make these changes is who is living in your house. You must think about who also is living in your house. If you have a boyfriend or girlfriend that has a previous domestic violence history, a child abuse history, a CPS history, those things can affect your fight for custody and parenting time. Because this is a person that is going to be around the child or the children for a significant amount of time because they are living in the house. Now, I'm not saying that a judge or referee is just going to look at that and make a snap decision in regards to, oh, well, that's the bad person. They should never be there. You can't have parenting time. But it will be weighed in regards to the safety of the home. Remember, domestic violence is one of the factors for the best interest of the child. Now, I've given quite a bit of information, so to speak, or background on these few things because they are very serious elements that parents really need to know when they are trying to determine who is best to raise their child. And I don't mean raise because the other person won't be around, but when you're going in and arguing with the judge or referee about why you're the better parent, you have to have all your ducks in a row. Now, some people may look at certain things, oh, that's not that big of a deal. My brother lives in the house, but, and he can watch the kids. That's not that big of a deal. That's family. Or the other parent who's trying to maybe say dad is trying to get more time, and he's not taking into consideration the factor that if mom has other kids that his child is attached to, that's going to be a factor that's pretty much going to be against him. Because that's an additional bond in regards to the rights of the children to maintain, not in regards to his rights. That's not something that's considered for dad. That is something that's considered for the child or mom. Now, all of these things, parenting time and custody, I guess I'll go that way. Parenting time and custody, and more so custody, affect child support. Child support is based off of the number of overnights a parent has. That is how child support is calculated. Child support takes the income of both parties, not just the person that the child, not just the person that has the custodial environment, but it looks at the income of the parent that has custody or the primary custodial environment, the parent that does not, who has the most number of overnights, who has medical insurance, who should provide more for make up for for expenses that don't follow, extraordinary medical expenses that are not under the normal calculation, and child care. All of these things are calculated together and they take out your deductions. They take out your exemptions and calculate down to what is your net income that you're bringing in a month, and then determine that percentage towards the child's care. So, for example, say mom and dad have 2 kids. Mom has 260 overnights. Dad has 105 overnights. Dad makes $50,000, mom makes $50,000. Now, on this face, most can look and say, well, they make the same amount. Yes, she has more overnights, but, dad's support shouldn't be that much because she makes the same amount. There's not a disparity in income. But here's the difference. Mom has the additional expenses from the children, whereas dad does not. Mom has the primary care for the children. Dad does not. Mom's income does not go as far as dad's if dad is just taking care of himself. So it will be calculated out, and dad will have to pay child support. Now, and it will likely, it can be higher than what some would think. Now, some dads will say, well, let me rephrase that. Some dads will forget sometimes to add in the fact that they have other kids that they are taking care of, that they have other child support cases, or that they have other kids in the new household that they're living in. That is calculated for child support, and that is calculated into the income, and it reduces dad's income that can be used for the other children in the other case. And that calculation is required under the Michigan Child Support Formula. It is required to take into consideration how many children are being taken care of outside of the parties. Now, another situation that's coming across is that where mom makes significantly more than dad, but they share custody, 50-50. So dad may say, well, she makes a lot more than I do. We have joint custody. Then there shouldn't be any child support. Well, under the calculations, even with 50-50 custody, mom could have to pay dad child support. It is not just the overnights, it is overnights and income. And if you have 50-50, the calculation takes into consideration that the child is required to receive the same type of care in dad's custody that they're receiving in mom's custody. The same type of living in dad's care as in mom's care. So please keep in mind that when you file a child support case, if you make more money, you can come out paying more even if you're mom. Even if you have joint custody, you can still have to pay child support. It is not just a set determination. So that's something that I'm finding that moms are getting shocked by. How is there an order for child support against me and we have 50-50? And that's when they come in for the evaluation. Now, I've tried to go over in general some of the background for parenting time and custody and child support. It is a very broad area in family law. There are a lot of things to be considered, and no two cases are the same. Everything is to be done in the best interest of the child, however. That is the one consistent point. Everything is supposed to be done with the child or children's best interest, whether that is with mom, dad, or neither. I find in a lot of the cases that are coming my way is that both sides are intent on getting what they want, not necessarily just what is in the child's best interest. And I don't think that comes from a place of each parent being greedy or each parent just trying to put the other down, or I don't think it comes from a place of each parent just being hard-headed, although sometimes that is the case. That's not the general scenario. What I find a lot of the times is that it comes down to is that the parents don't know what they need to argue or what has to be weighed and the high burden they have to meet before they can even go on that journey, before they make those arguments, before they make the decision to file a case. Now, like I said, there are some instances where case is going to be filed regardless. Like I said, if a parent receives aid that has custody of the child, the state is going to file a case unless dad lives in the home. And that is not up to the parent. That is solely up to the state to pursue that. But understanding, a basic understanding, an explanation, will help parents reach, a lot of the times, reach agreements in providing and caring for their child. Now, as I've gone through this, and I know I've probably have gone back and forth a little bit because these concepts are really intermingled. You know, the best interests of the child factors are not just for custody, but they're looked at parenting time. It's just a little different of factors. And I will go into these factors in depth individually in the series in this series of videos. I will go into that. But like I said, this is just for the general understanding. These factors are what helps a court who knows nothing about you make a decision for your child. The overwhelming issue is what's best for your child. Mediation can help in reaching that, not necessarily filing a motion. I have had situations where I've been able to have parents come in, not in a divorce situation, but come in and we actually craft an agreement without having to even go to court. If there was already a child support or a custody case that was in place a couple years down the line and it's no longer working for the parents, I've had parents be able to come in and come to an agreement. Now, in doing so, these are parents that agree that them together are not in the best interest of their child, but they're on the same pages of what's in the best interest of their child. Now, there will always be situations where you can't work something out. whether it's for safety reasons for yourself or the child, because there are incarceration factors, because there are CPS factors, abuse factors. Those are not the norm. Those are extenuating cases that obviously require a different level of review, a different level of expertise in handling. But all in all, most parents, if they take themselves out of it, can work out something that will be in the best interest of their children and work out some type of amicable agreement with the other side. Now, for this video, understanding the basics is what I was trying to get across. Explaining, not necessarily just understanding, explaining the basics of these underlying issues was the goal for this video. The others will explain more in depth the particulars of the factors, the particulars of joint, and the particulars of legal, and what those true burdens are. I thought that would be a little bit much for this video, considering that those three areas are already very broad to just do a general video on. But I also wanted to make sure that I could give some insight into what may be currently happening in your case and you're not even aware of, or what may be currently counting in your favor that you may not be aware of, and how to move forward in that, how to understand what the court is looking at, how to understand what the court is inclined to weigh more when it comes down to where your child should live and how much time your child should have with the other parent. There are also a lot of inconsistencies, unfortunately, when it comes down to different judges, when it comes down to different referees, when it comes down to different counties. It is not the same in every county. Even though the best interest of the factors are, best interest of the child factors are the same, the application is not always the same. What a judge is going to put more weight on is not necessarily the same. What I'm going to do right now is just read you what these actual factors are so that you know what this list is. And then I will go into more in depth in part 2, called the best interest of your child. So the first factor is the love, affection, and other emotional ties existing between the parties involved and the child. That seems very basic, and that most parents would be able to fit that. A lot of parents, that is an equal factor. For some, it is not, due to history. 2, the capacity and disposition of the parties involved to give the child love, affection, and guidance, and to continue the education and raising of the child in his or her religion or creed, if any. Now, that is a very verbose factor with a lot of sub-issues within. The capacity and disposition. Most people have the capacity and disposition to love their child, to give affection to their child. But then you can break it down into guidance and religion. And then that in and of itself can raise very big issues, particularly if the parents come from different religious backgrounds. Next, the capacity and disposition of the parties involved to provide the child with food, clothing, medical care, or other remedial care recognized and permitted under the laws of the state in place of medical care and other material needs. This is the basic factor that I discussed, as to who can help take care of the child. Are you able to provide a shelter, food, clothing, and medical care? Sometimes this is equal, sometimes it's not. It's more often equal than not. The length of the time the child has lived in a stable, satisfactory environment, and the desirability of maintaining that continuity. This is where I was discussing where if the parents separate the child lives with mom following separation, or dad lives with one of the parents following a separation for an extended period of time, and that parent has provided a stable environment, they're going to have that in their favor. The child is likely going to be stable living in that same home that they had been in for about, however long they had lived there, even prior to the other parent moving out. That is going to count. The permanence as a family unit of the existing or proposed custodial home or homes. Now, this is a situation where there's a lot of argument back and forth if one of the parents seems to have a continuous number of significant others, or one parent is now alleging that they're engaged and about to be married, and giving the court idea that they are now establishing a stable environment for the child to be in, and a permanent environment for this child. Now, engaged to be married does not mean married. There are a lot of judges that will not look at a fiance any differently than a boyfriend or girlfriend, because people get engaged and break up all the time. The moral fitness of the parties involved. This is one of those very subjective factors where a factual basis is really needed to make this argument. This is something where you really need to be candid with your attorney as to your history, so that nothing comes out later that can harm you in your fight to maintain or change custody. The mental and physical health of the parties involved. Now, just because someone has a heart condition doesn't mean that they can't have custody of their child. Or just because someone suffers from PTSD, which a lot of our veterans are suffering from, does not mean that they are not able to have custody of their child. That just means that they're going to look at that factor more carefully. How are you managing that factor? How are you managing that issue? How are you caring for yourself? How are you, or how have you taken steps to minimize the impact, if there's any, from your condition on your child? The home, school, and community record of the child. Where are they going to school? Where have they been going to school? Are they just starting at a new school? Then this factor probably isn't going to count. But are they a senior in high school and they're finishing out their last year at a school that they've been at since they started high school? That would be a very big issue. And that is a very big issue, to try to change a child for their senior year of high school. There would have to be some very overwhelming factors present to do so. The reasonable preference of the child, if the court considers the child to be a sufficient age to express that preference. Now, usually, a child over the age 13 and up is when a judge can, not always will, and not always do, but can ask the child who they want to live with. They can ask the child why they want to live there. And the biggest thing about this is these statements are kept confidential. What the child says will not be released to either parent. And even in doing so, the referee or judge will minimize the effects of that conversation sometimes, so as to not raise any type of animosity, potential animosity with a parent and a child, and also to make a child more comfortable in expressing what they would like to do. The willingness and ability of each of the parties to facilitate and encourage a close and continuing parent-child relationship between the child and the other parent, or the child and the parents. That was a long factor. And that is a very broad, subjective factor. That is almost like the kitchen sink of all the other factors together. And I'm going to tell you why. Because a lot of the times in situations of parental alienation, which will be discussed later, a parent can argue everything under the sun as trying to prevent the relationship. They can argue, oh, they changed schools without telling me. They're trying to change. They're interfering with my relationship. They have called the police on me countless times that were all baseless. That can be used in that factor as attacking the closeness of the parents. They keep talking about the case, which is a big no-no for every judge and every referee. They keep talking about the case to the child or around the child, within earshot of the child. That is a big issue. Almost anything can be used in this factor. Not answering the phone when you're trying to have a phone conversation with the child. A parent will argue that you're interfering. Not allowing a parent to bring a grandparent, or not allowing playtime with other siblings. That can also be argued. Almost anything that fits under these other factors, or maybe just doesn't fit all the way, can be argued under this factor. It is very broad, and it allows for a lot of leeway and open interpretation. And again, this is another factor where you really need to be candid with your attorney or the judge when you're trying to pursue or defend a change of custody. Domestic violence, regardless of whether the violence was directed against or witnessed by the child. So if you have a domestic violence incident with a former spouse in front of the child, that will count. If you have domestic violence with your spouse or significant other, not in front of the child, but you picked up a case, even if it was dismissed under 769 4A, which is the first time offenders program, it still counts. It is still admissible. If you have a history of domestic violence cases, it will count. If you have only dismissed case history, say you have 5 DV charges past 10 years, 5 DV charges, no true convictions, but actual police reports, cases were filed, and they were dismissed solely because the other side didn't show up or something like that. It still counts because you still had the DV incident and it's documented. Any other factor considered by the court to be relevant to a particular child custody dispute. That is another catch-all factor. If you can't fit it under these other ones, you can still argue it here. But another thing is this factor also gives the court a lot of leeway in what they use to base their custody decision off of. Say you're in Wayne County and you've had a FAME report, Family Assessment Mediation Evaluation. Okay, and they assess the best interest factors and say they come out 50-50. But the judge and the referee says, and the FAME report says, you should have 50-50 custody. Everything is equal. But the judge reads some of the things that are mentioned in the FAME report that they want to put more weight on, that they think are more pertinent to this particular case for whatever reason, that they think carry a lot more weight for whatever reason. That last factor allows them to do it. That last factor allows them to take in all things into consideration as to where your child should live and who is going to be the primary custodial parent. Now, those are the factors verbatim as stated in the statute. in regards to how your case for custody will be evaluated. There's a lot of factors here. There's a lot of information. There's a lot of facts. It's very fact specific to a degree, which is what makes it a case-by-case situation, where just because something happened in one case, you can't say it's going to happen in another. You can't guarantee an outcome in one as in another. Different judges, different referees, different counties, different attorneys. They all have a factor. So I'm going to go ahead and end the video. If you have any specific questions, any specific issues, anything like that, please feel free to give us a call or send our office a message, and we'll get to you. Again, my name is Attorney Kiana Franulik. I handle family law cases and CPS cases statewide. Let me know if there's anything that we can help you with, and we surely will. Have a great day and enjoy the weather. Bye.